Good morning. My intention today is to provide a quick update on some of the recent case law and other developments which affect the tax treatment of employee remuneration. Given that I've only got 15 minutes to speak, I'm going to focus on two of the recent cases relating to termination payments and on the latest changes to the PAYE regulations dealing with termination payments made after a P45 is issued. I also just wanted to take the opportunity to highlight the penal tax charge that can arise in certain circumstances where, for example, share options are exercised and any income tax arising is not made good by the employee within 90 days. This penal tax charge can operate very unfairly but has recently been upheld by the courts. I've included in the slides for information a reference to certain further additional developments worthy of note. So just looking at termination payments, and before looking at some of the lessons that can be learned from the recent case law, I thought it would be helpful just to have a very brief recap on the basic tax treatment of termination payments. Just by way of reminder, payments made to departing employees broadly fall into three categories. The first category is amounts taxable as genuine termination payments, where the first $30,000 is tax-free and there are no national insurance contributions. This category would include, amongst other things, payments received as compensation for financial loss as a result of the termination of employment. The second category is amounts treated as earnings. These are fully taxable and subject to national insurance contributions, and this category would include, for example, contractual termination payments and contractual pile-ons. And the third category is amounts which are not taxable at all, so there's no tax or NICs payable. And this would include payments made in respect of damages for injury to feelings in the context of discrimination claims. And often payments made to employees, in particular on the signing of a compromise agreement, will reflect a number of different elements, some taxable and some non-taxable. And some of those elements are reflected in the slides. And a number of issues can arise as to how the overall sum paid should be split. So, looking at the recent cases, as I said, there have been a number of cases recently which have considered whether or how the overall sums payable should be apportioned. I'm going to concentrate on the principles that can be learned from two of those cases, OT Obihara versus HMRC and Norman versus Yellow Pages. Looking first at the OT Obihara case, this involved Mr. Oti Obihara, who claimed he had been subject to racial discrimination and harassment whilst employed by Morgan Stanley in London. He had taken his case to the Employment Tribunal, but had eventually negotiated a settlement sum of £500,000 with Morgan Stanley, whereby his employment was terminated and he waived all legal claims, both in the UK and the US, against Morgan Stanley. And the question arose as to how much of the £500,000 was to be treated as a payment received in connection with the termination of his employment, and therefore subject to income tax except for the first £30,000, and how much was tax-free, being damages for the discrimination, including injured feelings. And this case is of interest because it confirms a number of points. The first is that a compensation payment made for discrimination will only be taxable if the discrimination is the cause of the termination of the employment, and then the payment will only be taxable to the extent that it is compensation for financial loss suffered by reason of that termination. Any other amount received represents compensation for the infringement of the right not to be discriminated against and is not compensation for the termination of the employment. The second point of interest is that the tribunal will confirm that it will look to the compromise agreement or the terms of any relevant employment tribunal award in the first instance to determine what the compensation payment is made for. But in the absence of any apportionment in the compromise agreement or award, the tribunal will look to the wider context to reach an apportionment on a reasonable basis. And I think the point to take away from this is that it's worth thinking about whether you should be expressly allocating sums against the various elements of the package in a compromise agreement to assist if HMRC were subsequently to seek to apportion amounts later on. And this is particularly the case where a payment may have a dual purpose, for example to compensate for loss of pension expectations, which would be non-taxable, but also to ensure the future good services of employees, which would be taxable. And this is precisely the situation the taxpayer found itself in the Kearney case, which is also mentioned in the slides. But it may actually not be feasible or desirable in all cases to make such an apportionment, and indeed the second case I'm going to look at deals further with this aspect. The third point arising from the Oti Obihara case is that the proper starting point in apportioning the compensation payment is to identify the amount which is taxable, i.e. which can be properly characterised as being in respect of the loss of office or employment, with the balance then being non-taxable. It's not correct, as HMRC were arguing in the case, to first identify the amount which can be shown as being for some other purpose, in this case injury to feelings, and in this case that was simply £28,000, with the balance then being in connection with the termination and therefore taxable. On the facts of the case, the tribunal held that only £165,000 of the £500,000 payment was compensation for financial loss on termination, the remainder being non-taxable. And the fourth point to take away is that the tribunal held that it was immaterial that Morgan Stanley had deducted basic rate tax from the whole of the compensation payment other than the first £30,000 under the PAYE regulations. The tribunal surmised that Morgan Stanley had done this from an abundance of caution, as they expressed it, where there had been no analysis of the nature of the payment when the total figure was agreed, leaving it to Mr. Oti Obihara to argue with HMRC as to the true nature of the payment. And it's worth noting that the approach of the tribunal here is not dissimilar to that of the Court of Appeal in the second case, which I'm just going to come on to. As I said, the second case I'm going to look at is Norman versus Yellow Pages. And in this case, Miss Norman had been employed as a sales consultant by Yellow Pages Sales Limited. She'd issued proceedings against Yellow Pages at the Employment Tribunal, including for sex and race discrimination, in particular injury to feelings, and for wrongful dismissal. A compromise agreement was reached via ACAS and approved by the Employment Tribunal, and under the agreement, which was in a standard form used by ACAS COT3, Miss Norman was to be paid £53,000 by way of compensation in settlement of the tribunal proceedings and in settlement of any claim arising out of her employment or its termination. The COT3 didn't apportion the total amount between compensation for loss of employment and compensation for injury to feelings, and the question of apportionment didn't appear to have been raised during the compromise discussions. Yellow Pages paid the sum to her, but withheld an amount in respect of basic rate income tax on the amount of the compensation payment above £30,000. And the point that came before the court was whether there was any implied obligation on Yellow Pages to apportion the £53,000 as between taxable and non-taxable elements, and calculate the PAYE payment to HMRC accordingly. The court concluded that no such obligation arose. It commented that, firstly, such an obligation could prevent settlement being reached. An employer may well not wish to acknowledge that he was liable or that a substantial part of the sum was paid for injury to feelings. Indeed, the essence of a compromise settlement is that neither party has to make any admissions. Secondly, the court had sympathy with the fact that employers were anxious to ensure that they were complying with their obligation to HMRC to pay any tax due, and also to avoid any suggestion that an apportionment had been agreed to the advantage of an employee if that were not the true position. And even if the parties had reached an agreement as to apportionment, it was made clear that HMRC would not be bound to accept it. So I think that the main point to take away from this case is that if a compromise is agreed which doesn't apportion its award between taxable and non-taxable elements, it's for the employee and not the employer to sort out the position with HMRC. If HMRC subsequently refunds money to the employee, this doesn't make the employer liable to the employee for having initially withheld the sum in the first place. And I think that this provides some comfort to an employer who may wish to take a cautious approach to withholding amounts in respect of PAYE obligations. There are just two further points which I wanted to touch on. The first is in relation to the penal tax charge that I mentioned earlier. I wanted to sound a note of caution in the context of, in particular, the exercise of employee share options. In a recent case, Chilcott and others versus HMRC has highlighted the penal tax charge which can apply if an employee doesn't reimburse to the employer income tax, but not NIC liabilities which may arise on exercise of a share option within 90 days. In such a case, the employer will be treated as making an additional taxable benefit to the employee on which income tax and NICs will be payable. And this is the case whether or not the employer has actually paid the income tax due to HMRC. Indeed, the penal tax charge often arises precisely because neither the employer nor the employee was aware that income tax was due through PAYE, or even that any tax liability was triggered at all. And the penal tax charge is non-refundable. So even if the employee reimburses the employer after the 90 days, or even pays the initial tax due through self-assessment, the further penal tax charge will still arise. And this is a point which is of relevance to employers as well as employees, because although any further income tax payable on the deemed taxable benefit is due through self-assessment, an employer will still be liable to account for NICs, both employee and employer, through the PAYE system. And so I think the point that needs to be taken away from this is that if employees are exercising share options, advice should be taken as to the tax position, and it's in everybody's interest for a method to be put in place to immediately recover any tax which is due from the employee. And finally, I just want to look at changes to the PAYE regulations which are going to come into effect from 6th of April 2011. In particular, I wanted to look at a recent change that has been made to the PAYE treatment of termination payments made after the P45 is issued. Currently, in such circumstances, the employer is obliged to deduct tax at the basic rate of 20% on taxable termination payments. But under the new rules, which apply, as I said, from 6th of April 2011, the employer is required to operate tax code 0T, and this essentially requires the employer to deduct tax at the relevant marginal tax rate, i.e. 20%, 40% or 50%, assuming no personal allowances are available and ignoring previous pay and tax detail. And this could result in greater amounts needing to be deducted, and in certain circumstances may result in the need to reclaim amounts from HMRC. And in such cases it may be worth considering making the termination payment before the P45 is issued. In addition, there are also similar changes to PAYE for new employees who don't have a Form P45 and who fail to fill out Form P46, and also for employees beginning to receive occupational pension benefits whilst continuing in employment. And more details on these are set out in the slides. And the final point I just wanted to touch upon, and which is referred to in the slides, is the new disguised remuneration legislation. As I said, the slides also briefly set out where we are in relation to that legislation, which will come into effect from 6th of April 2011. The legislation is aimed at schemes which seek to avoid or defer payment of tax and NICs on payments and benefits made to employees via EBTs and other similar vehicles. But the draft legislation goes much wider than this. As currently drafted, it can catch a number of straightforward commercial transactions such as deferred bonus arrangements and employee loans. HMRC have issued some frequently asked questions to give comfort on some of the areas of concern and have promised that the draft legislation will be subject to amendment to provide further clarity. And on this we are expecting to see a revised draft of the legislation at the time of the budget on Wednesday the 23rd of March. I'm not going to go into any more detail on this now, but again I'm happy to talk through the changes and the proposals in more detail with anyone who wishes to do so. Thank you.